Okay, we got a lot to talk about, and I'm glad I'm not here to talk about it by myself. So joining me right now from the Law&Crime Network, our fellow host here, Judge Ashley Willcott is with us. Judge, great to see you.
Good to see you, Jesse. Thank you.
I'm happy you're here because I want you to analyze what we've been seeing in this Court of Appeals hearing where it's all judges. So first, I got to ask the main issue here. The main issue is whether or not Ms. Gutierrez, who previously had represented Adnan Syed, did she fail her duties as an effective attorney for him by not interviewing this potential alibi witness? And again, you're hearing this back and forth about whether or not this alibi witness is credible, whether or not she had good information. Wasn't it her duty just to interview her in the first place?
Well, that's what the argument of defense is, or the appellate court argument on behalf of the defendant in this case. And Jesse, yes, I think every attorney has that responsibility. That's an ethical. You do have to look at alibi witnesses, any evidence that you're given from your client, the defendant, and actually determine then whether or not it's appropriate to call the witness. So she did have that obligation at the front.
But the counter argument to that could be there's been cases before where defense counsel hasn't interviewed alibi witnesses. It's part of their defense strategy. Is that the case here? Is that the right argument by the state, which we heard them make?
Well, you know, I don't know. I think that the rebuttal, the defense made a really good point in this argument just a minute ago, and that is this is an objective test. So it really doesn't matter why counsel for the defendant in the original trial did or did not call the alibi witness. That's not really the point that this court needs to consider. This court instead needs to consider, was it objectively unreasonable in the facts of this case, and was it unreasonable that defense counsel failed to call this witness or not?
And that's a legal question ultimately up to those judges. My question is, when you're sitting there, right, maybe give us an inside perspective about sitting on the bench. No matter what questions they ask, does that give you a sense of which way they're leading, or are they just trying to play devil's advocate?
I think they're always trying to play devil's advocate. That's what I do. You always, as a judge, I think, play devil's advocate and ask questions just to see what is the opposite side. What response are they going to give you to make certain that you have all the information and arguments of law before you from those two attorneys so you can make the best decision as the judge.
All right. At the end of the day, this is a case that everybody has been following. I mean, I listened to Cyril. I don't know if you listened to Cyril.
Yes.
Fascinating case about whether or not he was the person who killed Heyman Lim back in 1999. My question to you is, so his conviction was thrown out. A lower court, Court of Special Appeals, upheld a decision that's saying he deserves a new trial.
Right.
The state immediately appealed that. He's currently in prison because of these appeals, right?
Right.
What's going to happen?
Well, so since 2016, he's in prison because bail was denied. So even though it was overturned, 2 more years he's been sitting in jail. So the next options are either this court is going to find, yes, it was unreasonable and the court needs to be sent down, he needs to be tried again. And the prosecution could theoretically try to appeal it to the Supreme Court if they chose to. I don't think they're going to, right? I don't think that's going to happen. Instead, I would expect that we see another trial.
And he could be released from prison.
Yeah, absolutely. He could.
What a saga this is. And really, you got to take a testament to true crime here, because true crime podcasts, hear what we do on Law and Crime, it brings attention to different trials and cases. And you can argue that if it wasn't for Serial, we might not be sitting here watching this today. So it's a very different era we live in where media has drawn attention to certain cases. And really the question is, at the end of the day, did Adnan Syed kill Heyman Lee? We may never know, but we'll definitely follow the updates in this case. Okay, let's switch gears, though, and focus on our main live trial of the day. We expect it in under an hour. We're going to Chicago, Illinois, and we're talking about the police cover-up trial in relation to the Laquan McDonald shooting. Now, for anybody who's not really familiar with this case, doesn't know the details of it, didn't watch our coverage of the Jason Van Dyke trial, here's a report about a little bit of a summary of information on this case. Take a look. All right, the question is, did David March call this guy and say that Laquan McDonald lunged with a knife, which you can argue is not a true statement? Ashley, what did you make of that?
Well, here's the thing. So I think it's really imperative that the narrative that they're referring to, that this actual investigator wrote, didn't use the word lunged. And so I think it's very hard to hear, well, there was a call that said he lunged, and then that's not in my narrative. So I think on defense, that's a point for the defense, so to speak. And then while we were talking on break, you raised the fact that how does he know that it was March who called him and made that statement?
Is that effective? I mean, remember, they are not arguing in front of a jury. arguing in front of a judge, how does that differ here, especially if you want to just take this example right here?
Sure. We only have to convince one person, not 12. I mean, that's the biggest difference, right? And you're convincing one person who arguably should have a knowledge of the law and what the facts have to prove and the evidence being presented. But I do think it's effective to raise that point to at least make the judge think, well, maybe that's valid, maybe that's not. You know, everything you can raise, at least put it all out there for the judge.
Well, I want to examine that with you on the upside of the break about trying to convince a judge as opposed to trying to convince a jury. The difference is there a little bit more, because there is a difference there, a bench trial as opposed to a jury trial. Let's take a quick break. We'll come back. A lot more to talk about. Seems to be an attempt to justify what the officers ultimately did, but it also seems to justify in a way what the shooting, how the shooting happened, and that's my confusion. I want to bring in Judge Ashley Willcott to talk about this. We decided this issue. Jason Van Dyke was found guilty of second-degree murder and 16 counts of aggravated assault. Why are we talking about use of force? Because
they have to look at use of force when it comes to did these 3 individual police officers cover up the actions or not? And so was the use of force reasonable? So regardless of what happened to the defendant and what he was charged with and convicted of, Jesse, they still have to consider, was the use of force reasonable, and did they try to cover up that reasonable use of force or not? I don't know if that makes sense or if I'm confusing it.
Isn't the main issue what they said in the reports? And even if Jason Van Dyke, even if you could argue that it was justified, saying facts in the report that can be argued that never really happened in the shooting, I mean, does it matter?
Well, they've also been charged with conspiracy. And so looking at the conspiracy part, you have to say, did they make up those facts, change the facts in the report in order to protect, have a conspiracy to protect their fellow officer? And even if he used unreasonable force, say, it doesn't matter what kind of force he used, we're going to lie and protect him. So a conspiracy to cover up the use of force that was not considered reasonable. So they are linked in some respects, especially with the conspiracy charge.
It's interesting, and it's an avenue that we weren't sure they were going to explore, but they definitely did yesterday in court. Let's take a quick break. When we come back, more to talk about in anticipation of our live feed in about a half hour or so. We'll be right back. You know, Ashley, as we watch this, right, one of the things that you and I had talked about is an officer testifying against fellow officers. What do you think that's like for him?
I think it's horrible. I don't think any officer wants to testify against a fellow officer. They're subpoenaed, they have to, but the nature of the beast is they have to protect one another out there when they're out there protecting all of us. So they don't like it.
Especially since at least one officer in this case has been accused of being a rat. Of course, I'm talking about Dora Fontaine. We'll maybe get into her discussion a little bit later, but this is a guy who's testified now not in one trial, but 2 trials. He's also testified in Jason Van Dyke. Let's play a little bit more of his testimony, and Ashley and I will break it down. Okay, that was a key moment there, right? The idea of whether or not Laquan McDonald, how much of an aggressive attacker was he? Was this aggravated assault or not? Because we can't forget, in the reports that we saw the first day, they didn't call this a homicide. They said that he was a criminal, he got gunned down, this was an aggravated assault. I mean, based upon what you're listening to from Officer McGillicott, how does that relate to that report?
Well, so what he's saying is, look, he did have a knife. I told him 25 to 30 times, drop the knife, drop the knife. He didn't do it. I told him in different ways. He was the aggressor.
And how do you think this is helping the prosecution's case, or is it muddling issues?
I think it's muddling issues in a lot of respects. We were talking about use of force and whether or not that's important in this case. The way I think it muddles it is it provides the defense an opportunity to have some kind of defense. Because, Jesse, as you know, the reports are what they are. They report that Laquan attacked, and you see in the video he did not.
Right.
So obviously the report's not accurate based on the video. So they have to go with the use of force argument. So this all makes it pretty murky.
You told me something in break that I think we have to talk about right now. You had quite the prediction for this case. Can you tell us what you think might happen?
Yes, so Jesse, I'm not saying it will. I know all attorneys would advise Van Dyke, do not testify in this case, because if we want to appeal, that could affect that. I think these 3 defendants in this case are going to call Van Dyke, who's already been convicted.
But for what? How would that work?
I don't know. To muddy the waters, quite frankly, is what I think the defense would be doing. But I think they would be calling him to testify, look, the force I used was reasonable. Exactly the same testimony he already provided in his own defense, which didn't work, but to say the force I used was reasonable, he was a threat, this is what was happening, there was no conspiracy to cover up what I did.
Was he a good witness when he testified in his own trial? Because if they're making or breaking their case on what he's going to say, you think he was that great?
Okay, so you're putting me on the spot, uncomfortable, but I will say, no, I did not find that he was a credible witness at all.
And that's the problem for this defense counsel moving forward about what they might do. My question is, what is their strategy when the state ultimately rests? I mean, we have three separate defendants, three separate counsel. And each one of them is arguing a little bit of a different argument. Some are saying, let's just put all the blame on Laquan McDonald. Another is saying, just because the state disagrees with the report doesn't mean it's false. So what are they going to do moving forward, do you think?
I don't know. I think my best guess is they're going to say, listen, the evidence shows that there was use of force that was reasonable based on the witnesses we've cross-examined and presented, and that as a result, even if the reports are different, that it was chaotic, they reported the way they believed was accurate, but it does not show conspiracy, regardless of what the reports say, no conspiracy because the use of force was reasonable.
You know what we're going to have to do, Ashley? We're just going to have to wait and see. And that's what we usually do here on Law and Crime. So again, we expect a live feed, maybe in like 15 minutes, 20 minutes, as soon as we have a feed in that courtroom. Actually, we see the feed. It says they're on break. They haven't started yet, but as soon as it goes live, we're going to go live. Let's take a quick break on our end. You know, Judge, I realized I don't think I've ever asked you if you were surprised by the verdict in this case.
No, I was not surprised by the verdict in this case, in part because of his testimony. I do not think that Van Dyke was very credible, and after listening, I think a jury could find that that was not a reasonable use of force in these circumstances.
All right, well, let's see how he did back on the stand. We have a little bit more of his testimony to play for you. That's Jason Van Dyke testifying in his own trial several months back. Back here with Judge Ashley Willcott, very emotional on the stand. In your opinion, why did he really shoot Laquan McDonald so many times? You know,
I think the chaos and the nature of law enforcement responding in this particular case, I think, Jesse, he just kind of panicked and kept shooting. I don't think there were grounds. I think it was unreasonable, but it's almost as if he shot and then kind of lost control and kept shooting.
So sloppy police work, is that the way? I mean, because if that's the argument, then the argument here for these three people that are on trial right now is the question why their reports contained what's arguably false information. Is this sloppy police work again, or is there something more nefarious going on here?
I don't think we're ever going to know that. The conviction says, obviously he's been convicted of second-degree murder, but Jesse, there's no way to know which it was. I think there's a very valid argument, though, that there was a conspiracy to cover up, because whether it was sloppy police work or nefarious, I'm going to shoot and kill this man, either way, it's the same consequence.
And real quick, the question one of the arguments is that, hey, you may disagree with our reports. That doesn't make it false. We've got information based upon other people. We put it in there. What do you think about that?
I think with the videotape, that's a really hard argument to make because the reports don't match the video.
And don't you expect a little more?
Right. Absolutely.
Right. All right. Well, I'm done speaking because you, my friend, are coming into the hosting seat. I will be signing off. And Judge Ashley Willcott is going to guide you through our live feed today. We're waiting to go live any second. This is going to be day 3 in this police cover-up trial. 3 defendants, 3 different defense attorneys, and a lot of exciting things that are happening here. So we're going to take a quick break. When we come back, there is a lot more to cover, a lot more to discuss, and anybody who's been following the Jason Van Dyke, Laquan McDonald saga, you're definitely going to keep watching today. So now we're going to take our quick break. We'll be right back. Stay tuned here on Law and Crime.